On this episode of the Woody Report, Karen Woody and Tom Fox begin a multi-part exploration of a Caremark claim. In this episode, what was the underlying Caremark lawsuit that created the Caremark claim, and how did Marchand create a modern era of Caremark claim litigation? Hello everyone, this is Tom Fox back for another episode of the Woody Report, of course starring Dr. Karen Woody, or Professor Karen Woody. Karen, welcome back.
Thanks, Tom. I'm glad to be here.
So, Karen, I thought we could have some fun and be instructive as well if we have a few episodes dealing with Caremark and its progeny. It's a term that gets thrown around a lot today, and we typically call it a Caremark claim, but I thought maybe we could start with what was Caremark and how did Caremark create the Caremark claim?
That's a great question, and one that is a very pertinent question these days in particular. So let's talk about what Caremark is and why we throw that term around. Well, to start, I think we need to have a little bit of background about how the structure is that exists about suing companies, and in particular suing management and boards of directors. And so, as you may imagine, that's pretty hard to do. There's something called the business judgment rule, which effectively means that decisions of management and directors are given a lot of deference by courts, meaning courts never want to step in and tell a business how to run any of its operations. They will not look at maybe poor business decisions in hindsight and say you should have done this differently. There's very much this understanding that we will let companies and management run the companies as they see fit. And the only time we really will step in is when we think there has been some breach of fiduciary duty. And that's usually your duty of care, or duty of loyalty, again, something that can rise to something like bad faith. So there's a spirit of deference that exists between the courts and businesses. And so when, imagine something has gone wrong in a company, there are a number of shareholders who'd like to sue the company for mismanagement. That is usually a claim that's hard to bring for the most part, unless there's a significant amount of evidence that suggests that the company and the board in particular and management really whiffed, really violated their fiduciary duties of things like not self-dealing, putting the company's, the interests of the company first. That idea is where we're getting at. So Caremark was a derivative lawsuit. And what we mean by a derivative lawsuit is that shareholders are suing management on behalf of the company. So that's different than a direct lawsuit in which shareholders sue because they themselves have been injured and they want their money back. A derivative lawsuit is one in which the shareholders are suing on behalf of the company, meaning they're standing in the shoes of the company to sue because the company is what has sustained the injury as a result of the mismanagement that they are alleging. So already right there, that's getting a little in the weeds about the procedure that is the run-up to these types of claims. You're standing in the shoes of the company, so you're speaking on behalf of the company, but also alleging that company management, again, injured the company or certainly caused, it's usually, a loss of value, essentially. So what Caremark is a case that comes in out of 1996. It deals with this issue about directors who basically failed to show that they had set up any type of system of controls or monitoring. And in this case, it had to do with healthcare and the healthcare industry. What ended up happening there was that, they essentially turned a blind eye to a number of the red flags that occurred in that space. And so what we get out of this really becomes a new standard of what is required in order to hold the directors of a company liable, and individually liable, we should say that. Again, we're not looking at whether or not they made poor business decisions. The issue here is whether or not they had proper oversight of the company and its operations. And so what we get out of the Caremark case, again, I'm not going to spend too much time going to the individual facts of the case itself, because those have sort of fallen by the wayside, and instead this standard that emerges is what really is the long-standing, imprimatur, if you will, of what this case is. And what we get out of the Caremark Standard is really this two-pronged test. And you can succeed under either prong. And the first prong is that the board has set up, or there exists a system of controls and monitoring within the company. So we have to have a compliance program, some level of understanding the various risks that are associated with the business. That's the first prong. There's some sort of monitoring, and that monitoring runs all the way to the board. There's some board oversight there. And then the second prong is effectively that even if you meet the first prong, the second prong is that the board is actually meeting that, they actually are not turning a blind eye to what happens and what they've learned through that monitoring program. So it's not enough to say, sure, we have a compliance program, we have a system of controls and procedures in place and policies. If you're not doing anything about that, or if you're actively, knowingly ignoring any potential red flags that system uncovers, then that also is enough to be considered a breach of fiduciary duty, in this case a duty of loyalty to the company. And so what you have to show essentially is that ends up being the equivalent of showing that the directors are operating in bad faith, meaning it's a lack of good faith. They are consciously aware of potential risks and are not doing anything about it, or certainly have very consciously decided to not even look, not even set up a system wherein they would find potential risks or red flags. So from that, we have, again, it's a very exacting, it's a very hard standard to meet. But that kind of goes in line with what I've said before, which is it's always going to be hard to hold directors and management liable for various business decisions. And Caremark, again, made clear that it's still very hard maybe to meet this standard, but the standard got some clarity. We understood what it now means to succeed on one of these claims. So that's where we were in 1996. I don't know if that was sort of a long answer to your first question, but I think that helps set the stage for where we might go.
So you used a term in being a good tort aficionado. I want to throw another term in. But you used the term bad faith, and then you used the term gross negligence. Or I'm going to throw in gross negligence. And I recognize it's not a negligence standard, but when I first started practicing law, they had a big change in Texas around gross negligence. And the definition I learned in 1983 was the entire want of care. Or, as a senior partner explained to me, really, 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 really bad, as opposed to just bad. Or really, 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 really negligent, as opposed to just negligent. And I've always kept that kind of standard in my head. So I wanted to ask you, in the context of you being a tort professor, how do you help differentiate to students the difference between a negligence and gross negligence, or bad faith, and is it even valid to say the entire want of care, which is what I learned almost 40 years ago?
Yeah, it's a good question, and there's actually something that has been pretty heavily litigated in Delaware around exactly those seemingly, I don't know if I go so far as to say nebulous, but kind of hard to get our arms around what counts as enough that hits bad faith, or what rises to the level of just gross negligence. I should say there's now also Delaware statutes that cover like the duty of care. There's section 102B7 that carves out this liability of when you will be liable for a breach of duty of care that is determined by gross negligence. And duty of loyalty and good faith are sort of run together in a separate but parallel kind of silo, is how I would see that. But there's been a number of cases where they really are trying to say what is enough that proves bad faith. And we've seen a number. One of the most sort of famous involves the Disney company, a derivative lawsuit against Disney, and that is, I believe, from 2005. It was a little bit after Caremark, but they really tried to get their arms around what do we mean when we talk about bad faith. And so what they said there is there's a couple different ways to look at it. There's a subjective bad faith, meaning you had this actual intent, you get almost to an intent situation to do harm. And then the other one is sort of the opposite, which is, as you said, this gross negligent. You don't necessarily have bad intent, malevolent intent, but we have here, again, just the, utter failure to meet a standard here. This idea that you're not doing what is asked of you in your job or your position as a director here. And so in between sort of those two poles, where we have all the way like I'm intending to do some harm, I'm purposefully self-dealing, I'm doing something, with this intent to create some sort of bad act or certainly something that might injure the company, versus the other pole, which is this idea of like, well, I fell asleep at the switch here. I've done nothing, and one is not doing something enough here. And so that's, I think, what your question's getting at. And the answer is it's pretty tricky, again, to navigate. But Caremark talks about this idea of there are certain red flags or certain things that provide evidence that show that there is maybe gross negligence and or bad faith there. And so this idea of like, what does it mean to have a red flag? I mean, we'll talk through some of these cases that have to do with the Caremark Standard, and we see that there are certain things that are almost always a red flag. That usually is maybe some regulatory agency pointing out non-compliance with the industry standard, things like that. And if the board is ignoring that or purposely not handling that, those are kind of things that, again, show that you might be in the Caremark Standard, which, as you say, is this gross negligence and bad faith, but in that maybe sort of mix of all of that. I don't know if I answered that correctly, but I think it's a hard question, and one that has gone to the courts often, because it's hard to have a exacting standard for that, because so much of it would be a case by case type basis, a circumstance situation.
So, Karen, we had the Caremark case decided in 1996. There was maybe only one major Caremark claim case that I can recall of note, which was Stone versus Ritter. And that case just basically affirmed Caremark and said, yes, this is correct statement of Delaware law. And then we have had this explosion of Caremark cases, and we've had some successful Caremark cases. And I see the start of that as the Bluebell Ice Cream case, or as it was styled, Marchand case. I guess, and I should say the background facts were Bluebell Ice Cream is the third largest dairy creamery in America, had a listeria outbreak. 3 people died as a result of contracting listeria, and the board had done really nothing around food safety. And a shareholder derivative suit was brought, and it got to the motion to dismiss phase. What was it? The other maxim I love is bad facts make bad law. And we had some really bad facts here. And I don't know if that's what moved the court, but we seem to have a shift. And so it's a long-winded way of saying, did we have a shift? If so, why? But more importantly, what did that shift mean legally?
Right. So I guess I will clarify that. To say someone was successful on a Caremark claim, which means, again, shareholders are suing on behalf of the company. In this case, it's Bluebell Creameries, as you said. And what they were successful in was getting over a motion to dismiss, which is typically what the defense will file outright. Plaintiffs will say, we have a problem, here's our complaint, here's what we think the management has done wrong. And there usually is a sort of automatic motion to dismiss. Get out of here, business judgment covers this, you haven't met the standard of showing what you need to show under Caremark. And that's typically how most of the Caremark claims go, because as we know, it's a really high bar to get over this motion to dismiss. And there have been, I think, since Caremark, probably almost nearly 20 Caremark claims cases brought in Delaware, and only 5 have been covered, have cleared the motion to dismiss stage, and those have all been in the last 2 or 3 years. Marchand was the first one of those, and so it did seem like this kind of watershed moment where the court thought, wait a minute, this is something we're going to take a real look at. And Marchand case, and the ones that have followed suit, that have, again, been successful in getting past the motion to dismiss stage, they all have really bad facts, which I think we can't deny colors some of the outcome here, and you're right. So I do think some of the bad facts here move this almost impenetrable Caremark standard a little bit, an inch maybe, off of where it was before Marchand. And essentially what the court said here is, with all of this sort of extreme amount of, not extreme, but sort of a pretty voluminous record of FDA sanitation violations that Bluebell had from starting in 2009, and then the real outbreak in 2015 is what ended up killing 3 people, and another 7 were significantly ill. So it was a very, it was a really big deal. And so for this reason, again, I think the extreme nature of what had happened definitely colors the background of the case. But then the other, I think, important facts here that the court leans on is, one, Bluebell had one product. This wasn't a Johnson & Johnson or, Procter & Gamble, and one product had some, baby powder that wasn't great. This is the only thing you guys have to think about was your ice cream and if the ice cream is safe. So there's that. And then the other fact was, this was regulated in the sense that the FDA had toured some of their facilities and had founded countless sort of infractions with food safety compliance. And so, but all those things put together seemed like, what are you guys doing if not following up on this, having some level of oversight, having someone who knows about food safety on the board, looking into this? This would have been, the most important, critical, and the only product that Bluebell has. And so, of course, you need to ensure that it is safe for consumers. So I think you're right that the bad facts here certainly moved the court to grant this, motion to dismiss. I should say at the trial court level, they granted the motion to dismiss and they appealed, and the Delaware Supreme Court overturned that. So the Delaware Supreme Court said, I think we have enough here to show that there was significant, well, they should say, I guess I'm saying this in a very lawyerly way, but I think it is a procedural thing. The complaint did plead enough to show you could get past the motion to dismiss, that there is enough evidence here that the board did not have any system of controls or monitoring. And in fact, they went on the first prong for Marchand, meaning we don't see anything here that shows you're even monitoring this, as opposed to having a second prong claim, which is, all right, maybe you have some controls, but everyone ignored them. So that's why I think Marchand was actually a pretty big deal. And the defense was essentially that, which is, yeah, the FDA checks some things, we do some audits, like there is some monitoring, and some of that actually gets reported to the board because we have, what else are we talking about in our board meetings? We talk about some operational, topics, so we're doing enough. We're doing what Caremark requires, which, as we said a minute ago, isn't a lot. You definitely can't be doing nothing. And here the court said, yeah, well, this is the equivalent of doing nothing. You guys should have seen this coming. You had a number of violations already. And then, the result of this is that people have died from your product. There's certainly enough here that shows that, again, the board is not taking any measures to ask about food safety. There was no one on the board who knew anything about safety, certainly no board committee. There was no process to report to the board for management when they had learned about the violations. Instead, the board sort of had given them some rosy outlook about some things. And so, it was basically the court saying, you can't just bury your head in the sand. You can't say, we didn't hear about this for a while. And then when you did, say, well, yeah, they report to us. We have enough here to meet the low bar of Caremark. The court said, no, there's enough here. And so the result here is, again, a win in that they got over the motion to dismiss, which of course results in a settlement after that, because none of these cases are really going to likely go to trial. And so the win really is that you have cleared the motion to dismiss stage. So yeah, Marchand really was, a very big deal, because we had not seen any successful claims based on a Caremark standard, because as the court has even acknowledged, it's one of the hardest theories to prevail on as a plaintiff, because it's really, there has to be some monitoring, and then they're sort of paying attention. And if you have any evidence of that, you usually are okay. So that's why Marchand was, again, like a big shift.
And in reading the opinion, the court makes clear it was somewhat aghast at the actions of the board. But was it really those two facts, or those two Caremark prongs? One, there was no system of controls, and two, the board wasn't engaging in any oversight, which led the court to its ruling?
I think that's right. They said, there's enough here. I think the court says that there's enough to show that there was no board-level system of monitoring or reporting on food safety running all the way to the board. So for that reason, I don't know if this was your question, there really was a first prong of Caremark, meaning you didn't even establish a system of controls, as opposed to, you ignored some red flags. I mean, we have that here too. You could maybe, I think, be successful on either prong. But the idea that we actually don't see that there's any procedure or process or system of monitoring that means that the board has any oversight for food safety in particular. And so that's why that was, I think, a very strong statement by the court to say that.
So, Karen, unfortunately, we're near the end of our time for this episode, but I hope our listeners will join us where we continue our exploration of some Caremark claims. I hope you'll join Karen and I again for our next episode, where we continue our exploration of Caremark claims and litigations based on Caremark claims.